from Louisiana to Missouri to Texas. Republican legislatures are waging a war on women, all women, and they're taking away fundamental rights.
March 4, 2020, Washington, D.C., the Supreme Court. As justices inside were hearing an abortion-related case, outside the Supreme Court building, Senate Minority Leader Chuck Schumer addressed a pro-abortion rally and issued a direct threat to the justices.
I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions.
In a rare move, Chief Justice John Roberts rebuked the senator, calling the threat inappropriate and dangerous. The next day, Schumer gave a quasi-apology, excusing the threat because, after all, he's from Brooklyn, and they tend to speak in strong language up there. Ultimately, this kerfuffle shows how politicized the courts have become.
What's happened is that many judges have confused their own policy preferences with the requirements of the law. But policy and law are two very different things. And the court's job is never to make law. It's never to turn policy into law. It is to interpret the statutes and, most especially, the Constitution in terms of the intent of those who wrote the Constitution and the statutes, and then to apply that law as interpreted to specific cases. The making of law is to be done only by the legislature, not by the executive branch, not by the courts.
I think rewriting the Constitution to either include things that aren't written there or ignore parts that are there is the heart of judicial activism. This is a serious problem in our courts, and it comes from judges not approaching the Constitution as neutral arbiters, but looking at it as a tool to advance their policy goals. Well, the classic case, of course, is Roe versus Wade, where the court really created out of whole cloth a right to privacy without even defining that in the term of what privacy normally means. Saying privacy entails a right to abort one's own child doesn't really make sense. And of course, they classically said, we found this emanates from penumbras in the other rights.
You know, it's interesting. When the Founding Fathers set up the three branches of government, they set it up on the presupposition that we were sinful. Now, there's an interesting idea. And they decided, having lived through a monarchy, that giving too much power to a single entity never served the people well. So they went back and forth and came up with this wonderful system of checks and balances and came up with three distinct branches: the legislative, the executive, and the judicial. But in their minds at the time, of all three branches, the least important was the judicial. Now that's turned around. Now we look to the courts as the final arbiter of all truth in this country. So whether we like it or not, we have evolved or devolved, depending on your position, to a place where the courts really set the standard. The courts, by the way, were never designed to determine public policy.
Critics note that one of the most egregious decisions in recent times was when, in 2015, the Supreme Court suddenly discovered a new right to same-sex marriage in the 226-year-old Constitution.
Our Constitution takes no position on that debate, and where the Constitution is silent, we the people reserve constitutional authority to make policy. So we shouldn't have had 5 unelected judges making marriage policy for the entire nation. This issue should have been solved, like most policy issues, democratically. We the people, working through the democratic process, should have had our constitutional rights protected to make marriage policy, and instead we got judicial activism. There's a question of self-government here. You know, at one point Justice Scalia says, I don't care that much what the state says marriage is, but I do care who governs me. And he goes, I don't want to live in a regime in which Anthony Kennedy and 4 liberal judges govern me. I want to live in a regime where we, the people, govern ourselves. And so one consequence of this decision is what happens to constitutional self-government when that gets usurped and you have judicial tyranny instead.
Thus, the problem of judicial activism is that it undermines the consent of the governed.
Another consequence, and this is one that Chief Justice John Roberts points out, is that social change is better accepted when it's something that goes through normal deliberative processes. So if you fight a fair fight and you lose, you can accept that loss a lot better than if the fight was rigged. right? And so if you know that the umpires were in collusion with the opposing team, Deflategate, something like this, you can see people don't accept an unjust outcome if it's unjust and it had an unjust process.
It may be a slow and tedious process, but there are remedies available to we the people after some instances of judicial activism.
After the Roe v. Wade decision, Congress passed laws that made clear that pro-life citizens wouldn't have to perform abortion or pay for abortion. Activists at the time were saying, this is in the mid to late 70s, abortion's a constitutional right. Abortion is health care just like any other medical procedure. Every doctor, every nurse, every Catholic and evangelical hospital should have to perform abortion. The liberal activists lost that debate. The pro-life movement won that debate. Through the Hyde Amendment, the Church Amendment, the Weldon Amendment, the Mexico City policy, we had a variety of short-term solutions to protect our freedom. We need to do the same thing on the marriage issue. We need laws at both the federal and the state and local level to say no one should be penalized by the government because they believe and act on the belief that marriage is the union of a man and a woman.
Though our nation's attention has been on the coronavirus, we must remember there is a national election coming up. We will be voting for a president who nominates judges and for senators who confirm them.
The courts are determining decisions that have ramifications far beyond whoever the occupant of the Oval Office is.
It's important for us to step back and realize the role of the courts is to uphold the rule of law. And the highest law, the most important thing, is the Constitution. Now, one can amend the Constitution, you can change the Constitution, but until that's amended, that thing is a sacred document, and that's their job to uphold that. And if you lose that, this is why it now becomes so important, if you lose that, you've gone back before the American founding, before the American Revolution, to the old feudal days. Who has the most power rules. It becomes arbitrary. It becomes a hotbed of all sorts of potential things. It can go anywhere you want. And whether you're a liberal or a conservative, left or right, everyone should agree that's not a good outcome in a democracy.